Mr. Clement.
Mr. Chief Justice, and may it please the Court, the Federal Reserve is a uniquely structured entity with a distinct historical tradition. Part of that historical tradition is an unbroken history going back to its founding in 1913, in which no president, from Woodrow Wilson to Joseph Biden, has ever even tried to remove a governor for cause, despite the ever-present temptation for lower rates and easier money. Even in this case, the president recognizes the unique status of the Fed by neither arguing that the removal restriction is unconstitutional nor asserting the ability to remove a Fed governor without cause. But despite that recognition, the sum total of the Solicitor General's arguments would reduce the removal restriction in this unique institution to something that could only be recognized as at-will employment. No procedural due process before removal, no judicial review after removal, no preliminary injunction to preserve the status quo, and a conception of cause so capacious that apparent misconduct or gross negligence suffices. That makes no sense. There's no rational reason to go through all the trouble of creating this unique quasi-private entity that is exempt from everything from the appropriations process to the civil service laws just to give it a removal restriction that is as toothless as the president imagines. But if that removal restriction has real substantive and procedural bite, then this emergency application should be denied. There is simply no reason to abandon over 100 years of central bank independence on an emergency application on a preliminary record. I welcome the Court's questions.
But if there was such concern for independence, could the removal statute have been written, as others have been written, to require a hearing and review?
So it could have been, Justice Thomas, in the realm of interpreting statutes, coulda, shoulda, woulda, right? But I think that you have to give faithful interpretation to what Congress actually did. And I think if you understand the original public meaning of for cause in either 1913 or 1935, I do not think it was as capacious as my friends suggest. I think it probably meant INM plus ineligibility, and in the context of the Fed in particular, it probably picked up Section 244, which prevents a federal governor from also serving as a director and an officer of a bank. So if there were a Fed governor that insisted on being a director of Chase Manhattan, I think that would be removal for cause. And then on the context of the hearing, and I think Justice Kagan already alluded to this, but there are all these statutes about INM that don't mention a hearing, and there are many statutes that talk about cause and don't mention a hearing. Now, it's true that the NLRA, which was passed a month before, did specify a hearing. But I think it would be a mistaken statutory interpretation to make that one express reference to a hearing sort of disable all the other old soil arguments with respect to all the other institutions, where I think there's a very strong old soil argument that whether it's INM or for cause, that means that you get notice and an opportunity.
With that said, what would the hearing look like, and what would the review look like?
So I agree with General Sauer that the president would have a fair amount of discretion in how he or she wanted to fashion that hearing. I mean, one example we have historically is President Taft, and he sort of gave the removed officials the full Taft, and it was notice, opportunity for a hearing before an impartial tribunal that serendipitously included future Justice Frankfurter. And then so that's kind of the maximum that the president could give, but we're not suggesting that you need to give the full Taft. The president would have a lot of flexibility on that. I think you asked what the review would look like, and I think that actually sort of gets to the heart of where the president's incentives would be. I think the more process that the president provides, the less room there's going to be for judicial review and judicial second-guessing of factual determinations. So if a president wants to give the full Taft, I think the scope for review of factual determinations by that kind of tribunal would be very narrow, but I do think there would be legal review.